Welcome back to Notary Knowledge. I'm your host, Marylyn, and I am so thrilled you're joining us. Today, we're doing something a little special. We've dusted off the archives and are bringing you a standout conversation from the past. We have so many new listeners who might have missed this gem the first time around, and if you're a longtime listener, trust me, these are core signing principles you'll definitely want to refresh. So grab your notes, let's rewind the clock and jump right in. And remember, don't just be listeners of the knowledge, but be doers of the knowledge. I hope you enjoy.
Are you a notary ready to move beyond the basics? Don't get caught unprepared with legal risks and client pitfalls. You need a blueprint for success. Introducing Notary Knowledge Reference Guide and Notary Bible. This is your essential playbook. Learn to master your duties, build a thriving mobile business, and protect yourself from costly mistakes with expert advice. Find Notary Knowledge Reference Guide and Notary Bible by Derrick Spruill from Amazon.com, Barnes & Noble, Books of Million, Bookshop.org, Mobile Notary by DerrickSpruill.com, or download from Kindle today.
We operate in a world of binary validations, right? The state issued ID is either valid or, it's expired. The seal is either cleanly affixed to the paper or it's smudged.
Right. It's a very black and white framework.
Exactly. The signature on the document either matches the credential or it doesn't. The entire framework of legal execution is built on this expectation of structural, almost engineering level precision.
Yeah. You're looking for absolute certainty.
But the moment you slide a property bead across the table to, say, an 85-year-old signer who pauses just a second too long, or who looks at the pen as if they've forgotten its purpose.
That structural engineering completely crumbles.
Right. Suddenly, you're no longer dealing with binary checks. You are standing in the incredibly murky landscape of human cognition and neurodevelopment and aging.
And the real friction there is that the law demands certainty from a situation that is just, by its very nature, uncertain. I mean, the professional seated at that table is asked to navigate these diagnostic muddy waters, making these real-time assessments about capacity, awareness, and willingness.
Without a medic's degree.
Exactly.
Right.
All without the benefit of a medical degree or, a psychiatric background.
Well, welcome to Notary Knowledge. I am Marylyn.
And I am Eddie.
And you, listening right now, you are the third person in the room with us today. We know you're out there in the field, literally carrying the weight of the public trust.
It's a heavy burden.
It really is. So our perspective today is going to be high level, experienced, and really focused on the broader national landscape of notarial best practices. We are purposely avoiding hyper-specific regional anomalies.
Right. So you won't hear us getting bogged down in the granular details of, say, California's specific thumbprint requirements for every single deed variant.
Yeah, we're focusing on the overarching ethical and procedural frameworks that really govern our field.
Because the underlying mechanics of capacity and awareness, they don't change just because you cross a state line.
Yeah.
The physiological realities of aging and the professional liability you assume when you encounter them apply uniformly, whether you're operating in Maine or Texas or New Mexico.
Now, if you followed our prior shows, we've spent extensive time breaking down general fraud prevention.
Mm-hmm. And the strict mechanics of identity verification.
Right. We've analyzed the tactics for spotting synthetic IDs, dealing with sophisticated imposters, but today requires that exact same level of hypervigilance, just applied to a rapidly expanding demographic shift.
A massive shift.
Yeah. We are tackling what is known as the silver tsunami. So specifically, the ethics and operational realities of the aging population.
The demographic imperative here is just staggering. I mean, the baby boomer generation is aging at a rate that is fundamentally altering the landscape of legal execution.
We're seeing it every day.
Yeah, we're seeing an unprecedented surge of elderly signers executing wills, powers of attorney, advanced healthcare directives, and complex property transfers.
And with that volume comes the statistical reality of cognitive decline.
Right. Cognitive decline, physical impairment, and a terrifying vulnerability to elder financial abuse.
So our mission today is to pull apart the source material and build a framework to navigate those three specific hurdles: diminished capacity, physical impairments, and the silent threat of undue influence.
That's a lot to cover.
It is. But before we jump into the mechanics of this, elevate your own practice by picking up the Notary Knowledge books by Derrick Spruill.
Highly recommend them.
Yeah, the materials we're referencing today are heavily supplemented by the kind of masterclass field operations detailed in those texts. Also, rate the show, subscribe on your preferred platform, and share this podcast with your colleagues.
Because a more educated community creates a much stronger firewall against fraud.
Exactly. The material we are exploring today will give you the analytical tools to handle the toughest, highest liability dilemmas you'll face when seated across from a vulnerable signer.
It's going to be an intense exploration.
It is. We're going to establish the foundation of the silver tsunami right after a quick break.
We'll be right back.
All right, welcome back. Let's examine the sheer scale of the silver tsunami.
Not huge.
It really is. We are not just discussing a gradual demographic shift here. We are looking at a mathematical certainty that will impact daily field operations.
Oh, absolutely.
The American Psychological Association provides statistics on Alzheimer's dementia that, frankly, completely reframe how we should approach our daily schedules.
Yeah, the escalation in those statistics is what should grab every professional's attention. I mean, the APA reports that Alzheimer's dementia affects roughly 3% of the population aged 65 to 74.
Okay, so 3%, that's a manageable, though significant minority.
Right, but when you look at the very next bracket, individuals aged 75 to 84, that number jumps to 17%.
Wow, nearly 1 in 5 people in that bracket.
Correct. And then for those aged 85 and older, it skyrockets to 32%.
1 in 3 individuals.
1 in 3. And the critical context here is that Alzheimer's is merely one specific diagnosis, that 32% does not account for, like, vascular dementia or temporary medication-induced delirium, the aftermath of a stroke, or even just basic age-related cognitive slowing.
So I'm looking at those numbers, and the immediate operational takeaway is that if you are handling estate planning documents, executing hospital signings, or working within assisted living facilities,
They're going to see it.
you are mathematically guaranteed to encounter signers with diminished capacity. It is not an if, it's a when.
Absolutely a when.
Which leads us to a fascinating framework presented at a 2017 National Notary Association conference by Mike Closen and Mike Phillips. They introduced a conceptual division that completely changes how we evaluate a signer.
Yeah, this is groundbreaking.
They separated notarization capacity from transactional capacity.
I'd argue this is the single most important legal distinction a professional can internalize. The law actually recognizes two entirely different standards of awareness.
Right, break that down for us.
So the first, notarization capacity, is simply the individual's ability to understand that they are having their signature legally acknowledged or sworn to. That's it.
Okay.
The second, transactional capacity, is the individual's ability to fully comprehend the complex legal and financial ramifications of the document they're signing.
Which is much, much deeper. The source material breaks this down into a matrix of possible outcomes when you're sitting at the table. So outcome variation A is the usually scenario. The signer possesses both capacities.
Right, the ideal situation.
Yeah, they know they're in front of a commissioned officer, and they fully understand the dense terminology of, say, the commercial real estate contract they are executing.
Then you have outcome variation B, which is the sometimes scenario where the signer lacks both.
They're completely out of it.
Yeah, they're non-communicative, unaware of their surroundings, and clearly incapable of either understanding a contract or executing a notarization. In those cases, the path forward is obvious, right? You halt the process immediately.
But outcome variation C is the one that creates massive liability. The sources call this the rarely scenario, though based on those APA stats, I suspect it's becoming less rare.
I agree completely.
This is where the individual has the capacity to acknowledge a signature for notarization, but they completely lack the capacity to legally enter into the transaction described in the document. And I struggle to reconcile this.
It's tricky.
How is it legally permissible for a commissioned officer to notarize a document when they suspect the signer doesn't actually understand the contract itself? Aren't we facilitating a potentially invalid contract?
Well, you have to look at the underlying mechanics of the notary's role versus the attorney's role.
Okay.
The standard for executing a lawful signature for notarization is intentionally set as a much lower bar than the standard for contractual execution.
Right.
The notary is there to verify identity, basic awareness, and willingness. Do they know what the document is in a general sense? Like, this is a paper about my house, and are they signing it free from obvious coercion?
So we aren't judging their financial literacy.
Exactly. Understanding the dense legal ramifications of a generation-skipping trust or a complex power of attorney, that is the purview of the attorney who drafted it, not the notary who authenticates the signature.
Okay, let me test an analogy here. Is the notary functioning essentially as a legal bouncer at a venue?
Ooh, I like that, yes.
Like, a bouncer at the door of a club is not administering a breathalyzer. They're not drawing blood to check liver function to see if you have the transactional capacity to safely consume alcohol.
Right, right.
They are performing a threshold check. Does the ID match the face? Are you reasonably upright? Are you walking through the door willingly, or is someone physically dragging you inside?
Exactly.
They're looking for the absolute minimum requisite awareness to cross the threshold, leaving the deeper assessment of your consumption choices to the bartender inside.
That analogy holds up so well because it defines the boundaries of the duty. You are conducting a threshold check. Peter Van Alstyne, in his comprehensive text, Notary Law, Procedures, and Ethics, specifically addresses this exact ambiguity.
What does he say?
He points out that the standard of reasonable care in determining a signer's capacity to willingly and freely sign an instrument is notoriously ill-defined in statute.
Of course it is.
Right. Furthermore, he emphasizes that this notarial standard is emphatically not the same legal standard conventionally applied to issues of mental competence in a courtroom setting. The bar for the bouncer is much lower than the bar for the judge.
But that places an incredible amount of pressure on the professional at the table. I mean, we are the primary gatekeepers for the legal integrity of these documents.
We are.
We're making a layperson's judgment about minimum requisite awareness in a matter of minutes, often with complete strangers.
Which is why the liability is so severe. The standard of awareness might be lower than a clinical medical diagnosis,
Yeah.
but the consequences of a failure at that threshold are catastrophic.
Yeah.
If you allow a signature through when the requisite awareness is absent, a senior citizen could be stripped of their life savings, their real property, or their legal independence. The lower bar does not equal lower stakes.
And because the stakes are that high, you would expect a unified national legislative approach to how we assess that bouncer threshold.
You would hope.
But as we'll see, the state laws are a complete patchwork of contradictions. We are going to unpack that legal tapestry right after this.
Stick around.
We're back. So we established that the standard for notarial capacity is distinct from transactional competence. But how does a professional actually operationalize that when the legislative rules are just completely fractured?
The primary frustration for anyone operating in this space is the glaring absence of a universally accepted standard. I mean, only a handful of state statutes even direct their commission officers to explicitly consider signer capacity.
Really?
Yeah. And the language they use varies wildly in its strictness and subjective burden.
The sources provide some stark contrasts here. Let's look at Florida. Florida Statute Section 117.107 prohibits the notarization of a signature if it appears that the person is mentally incapable of understanding the nature and effect of the document at the time of notarization.
That is a very heavy observational burden placed directly on the professional. You have to make a judgment call on their mental capability to understand effects.
Right. And then compare that heavy burden to the language in Georgia. The Georgia Code allows the professional to decline the act if they have compelling doubts about whether the signer knows the consequences of the transaction.
The phrase compelling doubts is fascinating to me
Why is that?
because it implies a negative presumption. You assume capacity unless a doubt rises to the level of being compelling, which means you need a significant, observable reason to halt the process, not just a vague suspicion or a slight hesitation from the signer.
Ah, okay. Then you have a state like Illinois, which takes an incredibly specific but frankly practically unworkable approach.
Well, the Illinois statute.
Yeah. The Illinois Notary Public Act strictly forbids taking an acknowledgement from someone the notary actually knows has been adjudged mentally ill by a court and who has not been restored to mental health as a matter of record. I read that and immediately think, how often does a notary actually know a stranger's formal sealed court adjudication status?
You rarely ever would, unless a family member specifically hands you the court order to stop the signing. Statutes like that protect the notary by making the standard of refusal reliant on actual documented knowledge rather than subjective observation. But
Right.
they do very little to proactively protect the vulnerable senior who hasn't been to court yet.
Right.
This is why the most robust framework actually comes from case law rather than statute. The Maryland Court of Appeals case Poole v. Hyatt from 1997 established a four-part test that is widely considered the gold standard for assessment.
Let's break down that Marylyn test because it takes all this abstract theory and turns it into an actual operational checklist.
Yes, please.
Okay, part 1. There must be personal appearance before the notary. Part 2. The signatory must appear to be alert and under no apparent duress or undue emotional influence.
Very important.
Part 3. It must be clear from the overall circumstances that the signatory understands the nature of the instrument. And Part 4. The signatory must sign in the presence of the notary with the apparent intent of making the instrument effective.
If you satisfy those four criteria: appearance, alertness without duress, basic understanding of the instrument's nature, and intent to execute the signatory, is effectively acknowledging voluntary execution under the law.
It's so clean.
It completely bypasses the need for a medical diagnosis and focuses entirely on the observable mechanics of the moment.
But, the concept of capacity is so deeply intertwined with identity verification. You cannot protect an elderly signer from financial abuse if you can't definitively prove they are who they claim to be.
Right.
This brings us to another landmark Illinois case mentioned in the sources. Vancura v. Catras.
Vancura is a massive cautionary tale regarding the systemic failure of identification procedures.
Tell us about it.
So, the case centered around an employee at a Kinko's store, a man named Albert, who notarized a forged signature on a mortgage assignment. And the fascinating part of this case wasn't a complex cognitive decline issue. It was a profound foundational negligence in basic identity training by the employer.
The court records on Albert's testimony are alarming. He testified under oath that his corporate training taught him to verify identity simply by looking at the signature on the document and comparing it to the signature on whatever ID was presented.
Just a signature match.
Right. The attorneys in court asked him a hypothetical. If someone presented an official-looking ID that had a signature on it, like a Social Security card, which famously does not have a photograph, and they could forge a matching signature on the document, would he notarize it?
Oh, no.
Albert essentially answered yes because his training dictated that a matching signature was sufficient.
Which is a catastrophic misinterpretation of standard practice. The court deeply analyzed the Illinois statute, which at the time required satisfactory evidence of identity.
And what did that mean?
Well, while that specific iteration of law didn't explicitly spell out the requirement for a photo ID, the court looked to the broader industry standards, specifically referencing the 1984 and 2002 Model Notary Acts.
Okay.
The 1984 version explicitly defined adequate identification as a document issued by a state or federal government containing the individual's photograph, signature, and physical description. So the court ruled decisively that in the modern era, satisfactory evidence inherently requires, at minimum, a photograph and a signature.
So how does the Vancura ruling intersect with the Silver Tsunami? Consider the reality of a senior citizen who has been residing in a nursing home or like a memory care facility for 3 or 4 years.
Right.
They do not drive. They don't travel. What are the odds they possess a current, unexpired, state-issued driver's license?
The odds are incredibly low. Identifications expire, and there is zero logistical reason for a bedbound senior to visit a Department of Motor Vehicles to renew them.
Exactly.
So the professional arrives at the facility, the senior is perfectly lucid, and passes the Marylyn 4-part test with flying colors, but the only ID they have expired in 2021.
And because of the precedent set by cases like Vancura, we know unequivocally that we cannot default to accepting a Medicare card, a Social Security card, or a library card just because it has their name on it.
Wow.
The professional has to instantly pivot to state-specific contingency plans. If a valid photo ID is unavailable, you have to utilize credible witnesses.
Right, which means finding one, or often two, impartial individuals who possess their own valid, unexpired photo IDs, who can swear under oath to the identity of the elderly signer.
And returning to Vancura for a second, the case establishes a terrifying precedent regarding employer liability.
Oh, this is huge.
Kinko's took on the responsibility of training their employee. They even implemented internal corporate rules, like requiring a notarial logbook, which wasn't strictly mandated by Illinois law at that specific time.
Right.
When Albert failed to properly identify the imposter, the employer was pulled directly into the crosshairs of liability. The court found them responsible for official misconduct due to improper training.
So the lesson here is crystal clear. If you operate a signing agency, a law firm, or a hospital network, and you fail to properly train your staff on the rigorous standards of elder identification and capacity, you expose the entire corporate entity to massive financial and legal liability when fraud inevitably occurs.
Okay, I want to push back on a practical reality here, though.
Sure.
Let's say I'm commissioned in a state where the statutory language surrounding capacity is vague or perhaps entirely silent. Should I arbitrarily adopt the strict Maryland four-part test as my own internal operating standard?
That's a good question.
I struggle with the idea of a professional imposing a higher barrier to entry than their own state legislature requires. Is it better to overprotect the senior by applying an out-of-state standard? Or should I strictly adhere to the minimal requirements of my own jurisdiction to avoid overstepping?
The prevailing guidance from the Notary Public Code of Professional Responsibility suggests that in the absence of explicit state guidelines, the safest course of action, both for the public trust and for your own liability, is to refuse to proceed if you harbor reasonable doubts about the signer's understanding.
So aim high.
Yes. Adopting a rigorous internal framework like the Marylyn test does not violate a vague state law. It simply ensures you are exercising the maximum reasonable care. It is infinitely better to face complaints about being overly cautious than to rubber stamp a potentially fraudulent property transfer just because your state statute was loosely written.
So the mandate is clear. Protect the vulnerable at all costs. But how do we actually execute that assessment in the room without crossing the line into giving an unauthorized medical evaluation?
That's the real trick.
We're going to explore the practical techniques of assessment and the chilling modern threat of the invisible influencer right after this message.
Don't go anywhere.
And we are back. We are transitioning from the legal theory to the practical reality of the room.
Where the rubber meets the road.
Exactly. You are standing at the foot of a hospital bed or sitting across a dining room table from an elderly signer. How do you assess their awareness without acting outside the scope of your commission? The National Notary Association's Law Primer establishes a very clear foundational baseline. A document signer who cannot respond intelligibly in a simple conversation with the notary should not be considered competent to sign that document.
That is the ultimate floor of assessment. If you initiate a basic greeting, asking about the weather or how their morning has been, and they are entirely unable to form a coherent, intelligible response, the assessment is over before it begins. You pack up your bag. But assuming they can engage in basic speech, how do you probe the depth of their awareness regarding the transaction? The absolute non-negotiable rule in these scenarios is do not ask yes or no questions.
I see professionals make this mistake constantly.
Nice time.
They hold up a dense legal stack, point to the top page, and ask, "Are you signing a power of attorney today?" The senior nods and says yes. The professional assumes they have established willingness and capacity. In reality, they've proven absolutely nothing.
They've proven nothing because they are ignoring the psychological realities of cognitive decline. It is a well-documented phenomenon that individuals experiencing early to mid-stage dementia develop highly sophisticated social masking techniques.
Oh, wow.
Yeah. They realize they're confused, they feel vulnerable, and their defense mechanism is to become highly agreeable. They will nod, smile, and say yes to authoritative figures simply to mask their disorientation and avoid conflict.
To break through that mask, you must utilize open-ended questions. Peter Van Alstyne recommends asking simple, direct questions about the instrument itself. Instead of asking if it's a power of attorney, you ask, "Can you explain to me in your own words what this document does?" Or, "What type of document are we looking at today?"
And the response doesn't need to be steeped in legal jargon. If they look at the power of attorney and say, "This is the paper that lets my son talk to the bank and pay my electricity bill," they have successfully demonstrated the minimum requisite awareness.
Right, they get the gist of it.
Exactly. They understand the nature and the effect of the instrument.
But the assessment goes beyond just the dialogue. It extends to the environment and the timing. You cannot conduct a proper capacity assessment in chaos.
No, absolutely not.
If the television is blaring the news, hospital alarms are echoing down the hallway, and multiple family members are having side conversations, the senior's cognitive load is completely overwhelmed. You must request a quiet, controlled environment. Furthermore, the timing of the appointment is critical, specifically due to a condition known as sundowning.
Sundowning is a crucial physiological factor to consider when scheduling these appointments. It's a symptom frequently associated with Alzheimer's and other forms of dementia where confusion, anxiety, memory loss, and agitation significantly increase in the late afternoon and early evening.
So, end of the day is bad.
Very bad. The neurological fatigue of the day, combined with changing light levels, severely impacts cognition. A senior who is perfectly lucid, articulate, and capable of passing the Marylyn test at 10 a.m. might be entirely disoriented, combative, and incapable of executing a document at 5:30 p.m.
And beyond the timing, there's the issue of privacy. This is perhaps the most uncomfortable yet vital part of the job. You must meet privately with the signer. Elder financial abuse is rarely perpetrated by masked strangers. The statistical reality is that it is overwhelmingly committed by family members or caregivers, the very people who are supposedly helping the senior arrange the signing. You have to remove those third parties from the room to assess the signer's true, uncoerced willingness.
Which serves as the perfect pivot to discuss a massive modern vulnerability in our field: remote online notarization, or RON. The technology behind RON is an incredible advancement for accessibility, allowing homebound seniors to execute documents without traveling. But the architecture of RON introduces a severe risk factor that the sources refer to as the invisible influencer.
The mechanics of RON terrify me when applied to vulnerable populations. When you're conducting a transaction over a webcam, your field of vision is restricted to a tight, two-dimensional frame of the signer's face and upper torso.
It's very limited.
You have absolutely no visibility into the rest of the room. You cannot see who is standing 3 feet away just out of the camera's view.
You are entirely blind to the environmental context. You don't know if an abusive family member is standing out of frame, holding a threatening posture, physically pointing at the screen to dictate where the senior should click, or just whispering instructions.
Wow.
The coercion is completely invisible to the professional conducting the session.
It is the equivalent of administering an open book exam while someone is hiding under the desk whispering the answers. I know RON platforms utilize knowledge-based authentication KBA. Those are the multiple choice questions pulled from credit histories, asking things like, which of these addresses did you live at in 1998?
Right.
And the platforms use advanced credential analysis to verify the microprinting on the ID card. But I struggle to see how that solves the problem. All of that technology proves identity.
Exactly.
It does absolutely nothing to prove capacity or independent willingness. If you can't see the whole room, how can you legally swear that the signer is acting free from duress?
The blunt answer is that you can't swear to it with the same absolute certainty as an in-person assessment. You are forced to rely entirely on micro-expressions and conversational cues over a compressed video feed.
Like what?
Are the signer's eyes constantly darting off screen before they answer a question? Do they look tense or terrified? Do they pause unnaturally as if waiting for a silent prompt from someone off camera? Modern statutes mandate strict identity verification and secure electronic audit trails, but technology cannot legislate away the fundamental cognitive assessment challenge posed by an influencer you cannot see.
That perfectly isolates the danger of malicious third parties in the room. But what happens when the third parties hovering around the signer are not greedy relatives, but licensed healthcare professionals? Doctors, charge nurses, and facility social workers. That brings us to the massive intersection of legal execution and medical privacy, specifically the hurdles created by ICHP. We will dive into that complex web right after this.
See you in a minute.
We are back, and we are stepping directly into the high-stakes environment of the healthcare facility. Navigating document execution inside a hospital or memory care unit is an absolute minefield.
Yes, it is.
And the largest explosive device in that field is the Health Insurance Portability and Accountability Act, universally known as IPA.
Any professional entering a clinical environment must possess a working understanding of the IPA framework. It is structurally divided into 3 primary rules: the privacy rule, the security rule, and the breach notification rule. These rules are designed to create an impenetrable fortress around a patient's protected health information, or PHI. This includes any personal identifiers, details about past or present physical or mental health conditions, and anything related to the payment for healthcare services.
And the critical structural element of HIPAA is that these strict standards apply exclusively to what the law defines as covered entities. A covered entity is a health plan, a healthcare clearinghouse, or a healthcare provider who transmits health information electronically. Here is the friction point. Notaries are not covered entities. We are independent commissioned officers. Yet, our daily operations frequently require us to walk right into the center of these covered entities.
And that jurisdictional mismatch creates immense operational friction. Because you are not a covered entity, the medical staff views you legally as an unauthorized third party.
Makes sense.
So if you're standing at the nurse's station and you ask the charge nurse, can you confirm if Mrs. Smith in room 402 is mentally competent to sign a power of attorney today,
Mm-hmm.
that nurse is almost certainly going to freeze and refuse to answer.
Really?
Yeah. From their perspective, answering that question is disclosing PHI mental health status to an unauthorized party without the patient's explicit prior written authorization, which is a direct violation of the privacy rule.
I find the irony in this situation absolutely staggering. The sources highlight that under the specific provisions of the privacy rule, healthcare professionals actually do have the leeway to share information about an incapacitated patient, provided they believe it is in the patient's best interest.
Right? Like for care.
Exactly. For example, if a patient is unconscious, a doctor can share medical history with an incoming specialist or an ambulance crew to coordinate life-saving care. But the legal execution of a property deed or a financial power of attorney, that does not clearly fall under medical care.
No,
It falls into a massive, terrifying gray area. A nurse is not going to risk their license and their career guessing whether a property transfer to a nephew is in the patient's best interest.
Consequently, the hospital staff defaults to silence. They will outright refuse to provide a professional opinion on capacity to you. This creates a scenario where the notary must rely entirely and exclusively on their own layperson's judgment derived from direct interaction with the patient.
Because we have nothing else.
Exactly. You cannot rely on the medical charts at the end of the bed because you are legally barred from reading them. You cannot rely on the attending physician's verbal confirmation because they will likely refuse to provide it. You're operating entirely on an island of your own assessment.
To truly understand why the hospital administration is so incredibly guarded, you have to look at the mechanics of the HIPAA breach notification rule. It is not just a gentle slap on the wrist. The penalties are draconian by design.
Very draconian. The breach notification rule is engineered to enforce compliance through severe public and financial consequences. If a hospital experiences a breach of unsecured PHI, they are mandated by law to notify the affected patients, and they must report the breach to the Department of Health and Human Services.
Which is bad enough.
Right, but the truly punitive measure kicks in if the breach affects more than 500 residents of a state or jurisdiction. In that scenario, the covered entity is legally required to notify prominent media outlets serving that area. And they must do this without unreasonable delay, no later than 60 days after discovering the breach.
Try to visualize the sheer panic that causes in a hospital's legal department. Imagine a major healthcare network being legally forced to issue a press release to the local news stations saying, "We accidentally leaked the cognitive decline data of our memory care patients to unauthorized financial personnel."
It's a PR nightmare.
The public relations nightmare is catastrophic, and that is before you even factor in the massive civil monetary penalties enforced by the Office for Civil Rights. When you view it through that lens, it is completely understandable why a nurse will look you in the eye and refuse to tell you if Mrs. Smith is lucid today. They are defending the fortress.
Absolutely.
Which merely reinforces the reality that your independent conversational assessment skills are the only tools you have. You cannot outsource your judgment to the medical staff.
Exactly. Your role is not to procure a medical diagnosis. Your role is to authenticate the signature and verify the basic awareness and willingness of the individual sitting in front of you, utilizing your own observational faculties.
But let's twist the scenario a bit. What happens when the mental capacity is completely intact, like the patient is sharp, articulate, and fully aware of the transaction, but their physical capacity to execute the document is gone?
Oh, that's a tough one.
We are shifting the focus from the mind to the body next.
This is where the physical mechanics of signing collide with rigid state statutes, and the options become very complicated very quickly.
We've spent a lot of time on cognitive decline, but how does a professional proceed when a senior is completely lucid but physically compromised? Perhaps they've suffered a severe stroke affecting their motor skills. Perhaps they are paralyzed from a spinal injury. Or maybe their dominant hand is simply broken in a cast, rendering them physically incapable of holding a pen and executing a traditional signature.
When the physical ability to sign is compromised, you must explore alternative execution methods. The two primary legal avenues are signature by mark and signature by proxy. And the most vital warning I can give any professional is that state legislatures vary wildly and often contradictorily on what they legally permit.
Let's examine the mechanics of both. A signature by mark is a process where the signer, unable to write their full name, makes an X or another discernible symbol on the signature line to represent their intent, typically requiring the presence of additional witnesses.
Right.
A signature by proxy, conversely often referred to as a signature by direction, is a procedure where the physically disabled individual verbally directs another person to physically sign the disabled person's name on their behalf.
The application of these methods requires an encyclopedic knowledge of your specific state statutes. For instance, the states of Montana and Oregon have very strict boundaries. They explicitly prohibit a notary from acting as the proxy and signing on behalf of the disabled person.
Okay.
However, those states do allow a disinterested third party to sign by proxy, provided the disabled individual gives the instruction in person, visibly, and in the direct presence of the notary.
Then you have a state like Virginia, which the sources highlight as a perfect case study in statutory confusion and poor legislative drafting.
Oh, Virginia.
There is an incredible interaction recorded on the NNA hotline comment section involving a user named June. She was dealing with a high-pressure crisis involving a paralyzed signer. She researched the Virginia Code and noted that the law states a signature may be made by the use of any name, word, mark, or symbol executed or adopted by a party with the present intention to authenticate a writing.
Annie Mark.
The NNA confirmed to her that in Virginia, a mark made by a signer is legally treated exactly the same as a traditional cursive signature. There were absolutely no special notarial steps, witness requirements, or extra journal entries mandated by the state. The hotline representatives even confirmed that under this broad statute, a fingerprint pressed onto the paper could serve as a valid signature for a completely paralyzed signer.
The danger there is that such a broad, unregulated statute just invites fraud. Conversely, states like Nevada and Wisconsin take a highly prescriptive, heavily regulated approach to alternative signatures.
What do they require?
In Nevada and in Wisconsin, if a person is physically unable to sign, they can direct another individual to act as their proxy. But the notary cannot simply watch it happen and apply their seal. The professional must insert very specific, statutorily mandated phrasing as close to the signature as possible.
What's the phrase?
The phrasing must explicitly state, signature affixed by name of the proxy at the direction of name of the disabled signer. If the notary fails to include that exact language, the entire notarization is legally invalid.
So what is the protocol when a family is gathered in a hospital room, the signer's paralyzed, and there are absolutely no alternative options legally permitted in that specific jurisdiction? Suppose the state does not allow proxy signatures under any circumstances, and the patient lacks the motor control to even make a physical mark. What is the rule?
The firm, unbreakable rule of professional conduct is, do not proceed. If the physical requirements for alternative execution cannot be legally met in your state, you must halt the notarization. You pack up your journal, and you advise the family that they must contact a qualified attorney to explore alternative legal avenues, such as obtaining a court-ordered guardianship.
I have to highlight the extreme human frustration embedded in that scenario.
They're awful.
Imagine a daughter looking at you in a hospital room and saying, "You are telling me my mother's mind is 100% sharp. She knows exactly what she wants. She is begging you to notarize this. But because her hands are paralyzed and we happen to live in a state without proxy laws, she cannot sign her own power of attorney so I can access her bank account to pay for her life-saving medical care." That is a heartbreaking position to be in.
It is deeply empathetic, but the professional must remember that empathy cannot override the law. You are a creature of statute. You possess only the powers explicitly granted to you by your state legislature. You have rigid boundaries.
You can't cross them.
No. If you allow your empathy to dictate your actions and you operate outside of those boundaries, perhaps by letting the daughter guide the mother's hand when the state forbids it, you invalidate the document anyway.
Which doesn't help anyone.
Exactly. And more importantly, you risk stripping your own commission, inviting massive civil liability, and potentially facing criminal charges for facilitating a fraudulent execution. You must hold the line, regardless of how emotionally difficult the room becomes.
Those intense, real-world ethical dilemmas lead us perfectly into our interactive segment. We are going to put you, the listener, in the hot seat. It is time for Good Question, What Would You Do?
For this segment, we are analyzing actual real-world scenarios extracted directly from the source material and the professional community discussions. These are complex situations that professionals have actively faced in the field, requiring real-time judgment calls.
Let's dive into Scenario 1, the pain meds paradigm. This scenario draws heavily on the specific contexts of Florida and Nevada mentioned in our operational sources. Here is the situation. You are called to a hospital in Florida. The patient is a quadriplegic who has recently suffered multiple strokes.
Okay.
They are currently on heavy intravenous pain medications, specifically powerful narcotics, and the family has called you in because the patient wants to execute a last will and testament.
The analytical discussion here centers on compounding variables. How does the professional balance the physical inability to sign the quadriplegia requiring a proxy or a mark with the cognitive fog inevitably induced by heavy narcotics? You're dealing with chemical impairment, masking a baseline cognitive state.
A veteran commenter named Dan, who brought 42 years of notarial experience and a background as a nurse to the discussion, noted a critical reality. Even physically resilient, mentally sound young people lose their spatial and temporal orientation when administered heavy narcotics.
Yeah.
But as we established earlier with HIPAA, no doctor or nurse can legally look at your journal and confirm the exact dosage or cognitive effect of those narcotics. You are completely in the dark medically, so how do you proceed?
You must fall back entirely on your rigorous conversational assessment. You ignore the IV bags and focus on the interaction. Are they coherent? Can they discuss the specific ramifications of the will?
And what did Dan suggest?
Dan noted in his practice that if he detects the smell of alcohol on a signer, or heavily suspects they are under the influence of narcotics due to the hospital setting, but the signer is fully alert, coherent, maintains eye contact, and can clearly articulate the document's purpose, he will proceed.
Okay.
However, the critical caveat is that he meticulously documents his observations regarding their lucidity in his journal to counter any future claims of chemical impairment.
Let's contrast that with the Nevada context for a similar scenario. A professional named Teresa Shannon shared a fascinating localized practice regarding high-risk medical facilities.
I remember this.
In her area of Nevada, if an individual is residing in a hospital, an assisted living facility, or a group memory care home, and they request the notarization of a power of attorney, many local professionals require a physical note from the primary care physician stating the patient is capable of understanding the document, and they physically attach that medical note to the executed document.
She shared a profound anecdote where a judge explicitly told her that her consistency in this due diligence, her personal standard of requiring the doctor's note for facility signings, was the exact piece of evidence that settled a lawsuit brought by a disgruntled family member who claimed the elderly person lacked capacity.
That's amazing.
Yeah. While demanding a doctor's note might not be an explicit statutory mandate in every jurisdiction, establishing it as your own personal standard of operating procedure in high-risk environments serves as an incredible court-tested liability shield.
Moving to scenario 2. The young wife and the loan officer. This is a textbook study in identifying potential undue influence and coercion. Here's the situation pulled from the NNA hotline files. A professional is contracted to handle a loan signing for a 72-year-old gentleman. He is the sole signatory on the residential property. His name is the only one listed on the deed.
All right, setting the scene.
When the professional arrives at the home, the elderly man is flanked by a much younger wife and a highly aggressive, fast-talking loan officer. Throughout the preliminary introductions, the senior man is openly showing signs of reluctance, avoiding eye contact with the document, and hesitating to take the pen.
The environmental red flags in this room are blinding. You have an elderly sole owner of a major asset, you have overbearing third parties controlling the pace of the room, and you have visible physical hesitation from the principal signer.
Dozens of professionals weighed in on this exact scenario. Experts like Mikhail Yaniguez and Diana Smith accurately identified the required intervention. The immediate action is crowd control. You must politely, but firmly, ask both the wife and the loan officer to leave the room. You have to isolate the gentleman to speak with him privately.
That is the only way to break the coercive environment. You inform the parties that due to the sensitive financial nature of the documents, state best practices require a brief private consultation with the sole signatory.
And if they refuse?
If the wife or the loan officer aggressively refuse to leave the room, that refusal is a definitive, undeniable sign of undue influence. At that point, you terminate the appointment, pack your journal, and leave the premises.
Wow.
If they do comply and leave the room, you turn to the gentleman and ask him directly, using non-leading questions, if he is proceeding of his own free will and if he understands the financial burden of the loan. If he expresses even a shadow of a doubt or admits he is only signing to stop the arguing, you refuse the notarization immediately.
And when you refuse, does the interaction just end there? Do you simply drive away and forget about it?
Absolutely not. The interaction ends, but your administrative duty has just begun. You must document every single detail in your journal with forensic precision.
Everything.
Everything. You record the exact time, the names and demeanors of the parties present, the specific aggressive behavior observed from the loan officer, the visible hesitation of the signer, and the exact quoted reason for your refusal to notarize.
Because it might end up in court.
Exactly. Furthermore, a professional named Linda Fuller correctly suggested that if you genuinely suspect the elderly person is in imminent danger of financial ruin or physical harm due to the coercion, you should escalate the situation by notifying local authorities or adult protective services. You serve as a mandatory reporter of your own conscience, protecting the public trust even if your specific state law does not explicitly mandate you to call the police.
That is a heavy burden, but a necessary one. Okay, our final scenario, scenario 3. The Alzheimer's patient versus the social worker. This highlights the intense conflict between medical reality and legal authority.
This one is wild.
A professional is called to an assisted living facility to notarize a document for a resident they actually know personally. Upon arrival, the signer appears perfectly lucid and aware. The professional conducts the Marylyn 4-part test, asks open-ended questions about the document, and the signer answers them all flawlessly. They clearly know what the document is and what it does.
So far, so good.
Suddenly, a facility social worker bursts into the room, interrupts the process, and demands that the signing halts immediately because the patient's medical chart shows an official Alzheimer's diagnosis.
This scenario presents a phenomenal clash of perceived authority versus actual legal authority. The analytical question is, who dictates the capacity in that specific room? The facility social worker citing a medical chart or the commission notary citing their real-time assessment?
Many professionals, including Jennifer Gregg from Michigan, accurately pointed out the legal reality that a medical diagnosis of Alzheimer's does not equate to absolute legal incapacity at every given second of the day.
Right. Dementia fluctuates.
It does. If the signer is actively engaging in coherent conversation, maintaining alertness, and communicating their intent clearly in that exact moment, they possess the requisite notarial capacity for that specific snapshot in time, regardless of the chart.
And regarding authority, the social worker has absolutely zero legal authority to veto a notarial act. They are an employee of the facility managing medical care. Unless that specific social worker physically produces an active, legally executed power of attorney or court-ordered guardianship papers proving they have legal control over that specific patient's financial decisions, their demands are legally irrelevant to your execution of the document.
That makes total sense.
Now, their input provides valuable environmental context,
Yeah.
but it does not function as a legal veto.
I understand the theory, but in practice, standing in that room with an angry social worker, do you actually proceed with the notarization?
You have to make a highly nuanced judgment call based on the complexity of the instrument. A commenter named Margaret Drayden provided a brilliant analytical framework for this.
What was it?
She suggested assessing the cognitive level required by the specific document. Is it a relatively simple document like a basic will, which requires a lower bar of understanding, simply knowing one's basic property and recognizing one's heirs? Or is it a highly complex contract to sell commercial real estate, which requires understanding long-term financial ramifications, tax liabilities, and escrow consequences?
That's a great distinction.
If it is a simple document and the person is clearly alert and competent during your real-time assessment, you proceed, despite the social worker's protest.
But the crucial defensive step you must take is documenting the conflict. You do not just stamp the paper and leave. You thoroughly document the social worker's objection in the journal.
Yes, write it all down.
You write a narrative entry. Facility social worker interrupted the session and verbally objected, citing a medical Alzheimer's diagnosis. I paused the session, conducted an independent conversational assessment, asked open-ended questions regarding the document's nature, and found the signer to be entirely lucid, aware, and expressing free willingness at the exact time of execution. Proceeded with notarization.
That detailed journal entry becomes your impenetrable armor if the family attempts to invalidate the document in court 3 years later.
And that concept of the journal as armor leads us to the ultimate synthesis of everything we've explored today. The role of the professional at the table is evolving rapidly. You're no longer just an administrative rubber stamp verifying an ID card.
Not at all.
As technology advances, as artificial intelligence generates increasingly convincing fraudulent documents, as human lifespans increase, and as the silver tsunami continues to wash over our legal and financial systems, the professional notary stands as the ultimate ethical guardian at the gates of elder financial protection.
That's exactly right.
You are the sentinel standing between a vulnerable population and systemic exploitation.
I want to leave you with a final provocative thought to consider the next time you open your notary bag. We are entering an era of sophisticated deepfake voices calling seniors, AI-generated synthetic identities, and increasing physical isolation of the elderly.
It's scary.
In this environment, your physical presence in the room, your human empathy, and your rigorous, independent judgment are the single most valuable anti-fraud tools in existence. So ask yourself this question before every single appointment. Are my journal entries detailed enough right now to protect this elderly signer in a courtroom 5 years from now when their mind is completely gone? Because when their memory fails, your journal becomes their memory.
That is a profound standard to hold ourselves to. The murky waters of cognition and legal execution are not going to clear up anytime soon, but with meticulous documentation, an understanding of the legal tapestry, and unwavering ethical vigilance, we can navigate them safely and protect the public trust. We love hearing about your experiences navigating these complex scenarios out in the field. Email your questions, your challenging scenarios, and your field insights to Derrick at derrickspruill.com. We will try to answer as soon as possible at the end of our shows.
We want to extend a special thanks to the team that helps put this together. Executive producer, Derrick Spruill. Lead writer, Marylyn Trotter. Graphics, Eddie Montes Travis. Music, Thomas Bynum. Produced by Magnificent Workz Business Solutions.
Don't just be listeners of the knowledge, be doers of the knowledge. This is Notary Knowledge. Until next time.
Are you looking for an edge, flexible income, and immediate professional respect? Discover the hidden opportunity of becoming a public official with the book, Becoming a Notary by Derrick Spruill. This beginner's guide provides the universal roadmap to launch your new career. You will learn the core mission of deterring fraud, the essential tools of the trade, and exactly how to protect yourself while building a respected business. Get your copy of Becoming a Notary on Amazon, and step into a rewarding profession.
This is a robbery. I've been made into art, started from pottery, been at the bottom.